続きまして、大韓民国チームによる模擬裁判でございます。どうぞご登壇ください。それでは、ご登壇の皆様をご紹介させていただきます。裁判官役、大韓民国特許法院、イ・ヘジン裁判官。原告代理人役、キム&チャン法律事務所、ハン・サンウク弁護士。被告代理人役、キム&チャン法律事務所、イ・シオル弁護士。証人役、伊藤国際特許事務所、ユ・ガンヒ弁理士です。それではよろしくお願いいたします。
Good afternoon, everyone. It's an honor to be selected as the presiding judge of a mock trial today. I greatly appreciate everyone in attendance here. Before we begin, allow me to introduce the International Division of Intellectual Property High Court of Korea. The International Division comprises a panel of 3 judges who are all High Court judges. I'm Hae-jin Lee, a High Court Judge of Korea, and I will preside over this trial. Please assume that on my right and left, 2 High Court judges are seated, though they are not here today, so you cannot see them. Now I would like to proceed with the trial for the IP High Court case, number 2023-1017. We have the plaintiff attorney, Mr. Sang-woo Khan, and defendant attorney, Mr. Xiao Lee, in attendance. Before we begin the proceeding, let me provide a brief overview of the case process so far. The plaintiff filed a patent infringement suit against the defendant in Seoul Central District Court of Korea, seeking an injunction to prohibit the production of the defendant's product. The district court dismissed the plaintiff claim on the grounds that the plaintiff patent rights has been exhausted. The plaintiff then filed an appeal with the IP High Court and requested an international trial. As you see in the slide, a pre-trial hearing was conducted via video trial, and a technical explanatory session was held in the presence of judicial technical examiner. The plaintiff applied for witness summons, with this court approved. The issue in this case in whether the defendant's act of separating the used core tube from the plaintiff's patented product, roll paper, or winding a packaging sheet onto the core tube constitutes an act of production that harms the identity of the plaintiff's patented product. In this regard, the following 2 have been discussed. Firstly, whether the patented product loses its utility as a product after a single use. Secondly, whether the replacement of the packaging sheet for the plaintiff's used core tube constitutes a change of essential component of the invention. In today's trial, there will be arguments presented by attorneys for both the plaintiff and the defendants, as well as witness examination. First, the plaintiff attorney will present arguments.
Thank you, Your Honor. From now on, the plaintiff counsel will make the technical presentation. The contents of my technical presentation was composed as follows. The gist of the subject patent. I'll show you some animation to give you the better understanding. So this will show you the packaging process of the article packaging device. I hope this animation will give you the better understanding of what the patent gist is. I'll show you another animation. This is a core tube, and then packaging sheet. And then combined, roll holder is combined into the core tube. That's what the actual product is operating. So problem to be solved by the invention starts from the breaking force needs to be reduced as the outer diameter of the roll paper decreases. However, the prior art cannot or could not solve this problem. Prior art has the sensor for detecting the outer diameter of the roll paper is disposed on the side of the roll paper. However, the correct outer diameter cannot be detected because distortion of the roll paper. And secondly, the correct outer diameter cannot be detected due to the rotational deviation between the roll holder and core tube of the roll paper. How this invention solved the problem? That was to detect the rotation angle of the roll paper together with the detect of the sheet feed length. By detecting the two factors, this invention solved the problem, which was not solved by the prior art. So from now, I will present my argument that the dependent product and infringement action. So dependent product, as you know, the total wholly owned subsidiary of the defendant that wins the packaging sheet on the used core tube. So the subject patent to the dependent product has not been exhausted at all. Even though the Korean Supreme Court did not make any express the decision on the international patent exhaustions, here in our case, given the territorialism of the patent, the plaintiff patent has not been exhausted at all. And defendant product lost identity with the original product by winding the packaging sheet around the used core. This is the key issue before us. The Korean Supreme Court rendered a decision for what it is the standard for the determining where the repair or replacement of the consumable constitute a patent infringement. 4 factors was mentioned in the Korean Supreme Court case. 1, objective nature of the product. 2, the manner the product is used. 3, legislative purpose of the Patent Act, and lastly, the function of the product. These 4 factors has been considered whether or not the replacement or repair of the consumable would constitute the infringement. So defendant product, based on these 4 factors rendered by the Korean Supreme Court, without any doubt, defendant product lost identity with the original product. Winding the packaging sheet constitute the replacement of the important and essential element of the patent. Therefore, the act of winding the packaging sheet on the used core tube of the plaintiff roll paper is not the simple replacement. It's not the permissible act under the Korean patent law. Secondly, the plaintiff roll paper has lost its identity when the packaging sheet is used up, because it is difficult to secure the quality of the part of the core tube of the plaintiff roll paper when it's used after recycling. I will present 2 key evidence from now. One is the test result. The purpose of the test is to confirm the error between the calculated outer diameter of the plaintiff product and defendant product. What was the outcome of the test by the Korea Institute of Machinery and Materials? Plaintiff roll paper's error rate is just 2.4, while the dependent one is the 4.1, which means that the outer diameter of the roll paper of the defendant was not accurately calculated. Second evidence is the consumer survey. The method, online, subject, and area. And we asked the 4 questions to the consumers. First, how do you dispose of the core tube after using the roll paper? As expected, not surprisingly, more than the 96%, the consumer replied that I threw it away. Second question was, which company's roll paper do you use? So plaintiff has the majority. And third one is, if we have used both companies' roll paper, which company's quality do you feel better? Answer, as you can expect, the plaintiff has much better evaluation among the consumers. Last question we did was what's the reason for your better evaluation for the plaintiff product? There are some answers, but the noticeable one is the packaging result was excellent. Therefore, through the survey, it was confirmed that the act of winding again the packaging sheet on the used core tube of the plaintiff roll paper has removed the identity with the original product. So I just make the very brief rebuttal against the defendant argument. One, defendant argued that identity of the product has been maintained, but it is a very clear mistake because that disregards the problem of the patent invention solved. Secondly, defendant argued that the act of winding the packaging sheet is the mere replacement of the consumable. Again, this argument failed to consider how the consumer used the roll paper in the market, as was clearly confirmed by the consumer survey. Conclusion, the international exhaustion cannot be recognized. And then secondly, defendant product lost the identity with the original product. That ends my presentation, Your Honor. Thank you.
Thank you for plaintiff attorney. Defendant attorney will make your arguments.
Thank you, Your Honor. So defendant's counsel will make a presentation. let me start. So we have contents for today's presentations. So we have two issues before us. The first issue is whether international patent exhaustion is recognized. The second issue is whether the patent rights remain existed upon the act of replacing consumables. So we have good two Korean cases for these two issues. So the first issue, so at least one district court in Korea affirmed that international patent should be exhausted. So we think it is equally applicable to our case. And on the second issue, so we have a good IP, high court cases who detailed this type of cases. So in the interest of time, so I will focus on the second issue today. So from the IP High Court, we can derive key factors to whether the patent rights are exhausted in this case. So the bigger question is that whether is the identity of the plaintiff's product maintained after replacement of a packaging sheet? Yes, the answer is yes, definitely yes. So I'll explore more specifically these two key factors. The first, the objective nature of the patented product, and the second, the manner that the patented product is used. Now I first explain defendant's products. So defendant's products detects the rotation angle of the roll paper and adjusting the braking forces, thereby preventing poor fusing of packaging sheet. So when defendants making the products, the core tube, the magnets in core tube does not get any damages. Even the core tube is made of hard plastic, so it doesn't get any damages. So if you see the two components, in the the red one is a rotation angle sensor in the packaging article device, and the second, the magnets in the core tube. If these two things work properly, and there's no problem at all. So very simple and easy, not complicated. So objective nature of the patented product. The patent aims to measure the rotation angle of the roll paper and thereby adjusting the braking force applied to the roll holder. Otherwise, so the packaging sheet would be sagging like this picture. So let me show you some animation to demonstrate how the product works for the patented products. So as you see that the core tube is inserted into the core holder. So you see that two forces, tension and braking forces. So the magnets in the core tube and the rotation angle sensor in the article packaging devices, they interact to each other. So finally, the torque by braking force is equalized to torque by tension. Again, very simple and easy, not complicated. Now the manner that the patent product is used. So first, winding a packaging sheet inflicts no damages at all in the magnets. And secondly, so if you have a proper size of the packaging sheet, that it can fit into the core tube of the plaintiffs. 3, so a packaging sheet is originally supposed to be replaced very frequently when it is done. So the conclusion is that the replacing packaging sheet of the plaintiff's product is not a replacing essential element of the patented product. Defendant submitted at least 3 evidence to support defendant's arguments. The first one is the employee of K Measurement Center. So he conducted experiments on both plaintiff and defendant's products. the two things. The first one is that error in rotation angle measurement. And the second one, the number of rotations before a packaging sheet is cut. Simply put it, it is the lifetime of the products. And his testing result says that the two products were not different in performance. They are almost the same. He also submitted the test report. If we see the right side table, then you can see that error rotation angle measurement, defendant 3.1%, plaintiff 2.8%. Not so different. Even the lifetime is almost the same. So we also conducted a user survey. From this user survey, it is confirmed that users are not selecting products because of the brands or because of the sources, trademarks, but instead, users are selecting products because of the prices and because of the packaging sheets designs and colors. So it means that so there is no difference in performance at all. Even if there is a small difference in performance, it doesn't matter. It doesn't matter at all when users selecting the products. Now the conclusion. So the essential element of plaintiff's roll paper is the core tube, more specifically the magnets in the core tube. And secondly, as a matter of fact, so it is true that the plaintiff product is reused by not only defendant but also third parties. So there is no presumption that the product will be used only once. 3, so replacement of packaging sheet is not a replacement of essential elements of the patented products. So the defendant respectfully requests the court to dismiss plaintiff's claims. Thank you.
Thank you for plaintiff defendant attorney. And now I have questions for the plaintiff attorney. Can you provide evidence to support the claim that the defendant's act of winding packaging sheet on the plaintiff court tube constitutes an act of patent infringement?
Yes, actually, today I provided two evidence, one the test outcome and then survey result. But in addition to that, plaintiff counsel filed a testimony for the key witness, Mr. Yu. So I hope, Your Honor, you can accept my request.
Defendant attorney, what do you think of the evidence submitted by the plaintiff?
So first, the test report. Defendant also submitted a test report that is contrary to the plaintiff's test results. And because the burden of proof for infringement lies on the side of the plaintiff, not defendant. So now that the infringement is not proven yet. Secondly, about the plaintiff's witness. So he was not involved. So he was involved. He was involved in the early stage of the developing the defendant's products. But he was not involved in the final commercialized products. So he has a limited knowledge. So his testimony should be regarded because of he has a limited experience of the defendant's products. Thank you.
Okay, thank you. The plaintiff has requested Mr. Gwang Hee-yu as a witness to prove their claims, and this court has approved the questions. And is Mr. Gwang Hee-yu present? If so, please stand up. Mr. Gwang Hee-yu, please be note that if you are sworn in before the court and make a false statement, you will be punished for perjury. Are you okay? Okay. And please raise your right hand and take the oath as a witness.
I swear that I tell the truth in compliance with my conscience, without concealing or adding anything, and that if I make a false statement, I will accept punishment on a charge of perjury.
Thank you. You may now be seated. Plaintiff attorney may proceed with the questions for the witness.
Thank you. The Mr. Yu is the very, very important the witness. Actually, the plaintiff side had a hard time to invite him to the court because he had some reluctant to testify, but now actually he decided to come to the court to tell the truth. So I'll ask some questions for the Mr. Yu, the witness. First question is, from September 2017 and then March 2020, you worked at the Manufacture and Technology Division of the Total Corporation, which is the defendant Japanese subsidiary. Is that correct?
Yes.
Okay. And second question is, it is difficult to separate only the core tube from the plaintiff roll paper that has been used up because the packaging sheet was attached to the core tube using heat. Is that correct?
Yes.
Very good. And thirdly, it is difficult to maintain the quality of the final product made by rewinding of the packaging sheet if the previous packaging sheet has not been completely removed. Is that correct?
Yes.
And then next, I'll ask the very important question. The Total, which is the subsidiary of the defendant, used specially manufactured equipment to rewind a packaging sheet around the core tube with precision. Is that correct?
Yes.
Okay, it's very important testimony, I believe. And then relate to that question, it is possible for the general users like myself to easily wind the packaging sheet without help of this specialized equipment?
No. Winding a packaging sheet requires precise skills, so it is not easy for general users.
Thank you. So that means that myself cannot do without assistance from the specially manufactured equipment. 6, the imprecise winding would like to lead the packaging sheet to be cut during use. Is that also correct?
Yes.
My last question is, Total also went through a series of trial and error in the beginning of the manufacturing its rewound roll paper due to the unsecured precision. Is that also correct?
Yes.
Well, that ends my questions, Your Honor. Thank you.
Okay, thank you. Defendant attorney may proceed with the questions for the witness.
Yeah, thank you, Your Honor. So, Mr. Yu, I'd like to tell you first that, some of my questions would be offensive, but please understand that it is necessary to let the court know that your testimony is credible or reliable. Okay? So I'll begin my question.
Yes.
So you were dismissed from Total in 2020. Is this correct?
Yes.
So the reason you were dismissed was that you took the bribes from one of the vendors in relation to sample development. Is it true?
No, it wasn't a bribe. It was just a holiday gift, which are widely accepted in this industry. I was forced by accused. Someone in the company made the accusation, and I was found guilty receiving bribes. But I am innocent. Also, my testimony has nothing to do with that. I am telling you only the truth.
But it is also true that you were convicted by the court.
Yes.
Okay. So 3, Total's products was first released in September 2022, but you were dismissed in 2020. So you never engaged in testing the newly released defendant's product. Is this correct?
Yes.
You never engaged in comparing or analyzing the current 2023 version, total product, and the plaintiff's product. Is this correct?
Yes.
So the witness stated that he has limited knowledge of the first defendant's product and even the current product. So defense counsel requests that his testimony should be disregarded. Thank you.
Thank you. Now the panel will ask of questions to the witness. Mr. Gwang Yu, what have you been doing for a living since you left the corporation of Total in 2020?
Drawing upon the know-how I learned in Total, I collected the plaintiff's core tube and made and sold roll paper. Before I received the warning letter from the plaintiff in June 2023, and I ceased my business.
And you said that producing roll papers requires specially manufactured equipment. How did you make roll paper when you operate your own business?
When I was leaving the Total, the technical team manager gave me the equipment as a gift, and I could make roll paper using the equipment.
Okay, thank you. This concludes the witness examination. Plaintiff attorney and defendant attorney, do you have additional arguments or evidence to present?
Actually, I presented all of my argument and evidence. No further things, Your Honor. Thank you.
So defendants have no further evidence to submit. Thank you.
Okay, thank you. First, the plaintiff attorney will make a closing statement.
Through the test data and survey, the plaintiff confirmed that the defendant roll paper is not a high quality compared to the plaintiff roll paper. Secondly, through the witness examination, plaintiff confirmed that it's not easy to separate only the core tube from the plaintiff roll paper. And secondly, it is difficult to maintain the quality of the final product of the defendant product. Third, although defendant argued that the rewinding the packaging sheet around already used core tube would not affect the identity with the original product, the fact as verified and confirmed, especially by the testimony of Mr. Yu, showed that defendant's such argument is not the reasonable at all. Therefore, the importation and sales of the defendant product should be construed as infringement of the patent right. Thank you.
Okay, now the defendant attorney will make a closing argument.
Thank you. So, in accordance with the district court decision, international patent exhaustion should be accepted in this case. And secondly, evidence such as the test report, the affidavit, the user survey shows that the identity with the original product is unchanged. So, plaintiff submitted Mr. Yu's testimony, but it should be disregarded because he has, through the cross-examination, he shows that he has no knowledge of the final product, which is totally different from the early stage of the first product. And also, there are plenty of reasons that defendants believes that Mr. Yu, the witness, has bad feelings against the defendants. So his testimony should be disregarded. So, so finally, the plaintiff's patent rights are exhausted. So the plaintiff's claims should be dismissed. Thank you.
Thank you. As there are no further arguments or evidence, today's session is now closed. The court's decision will be rendered at 3 p.m. on October 17th, 2023. The decision will be written in Korean, and an English translation of the decision will be provided to the parties. Today is the decision date. I now render a decision of the IP High Court. First, the lower court's decision shall be revoked. Second, the defendant shall not produce, use, transfer, lend, import, or exhibit the defendant's product model total 1017. Third, the defendant shall bear the total cost arising from the lawsuit. First, paragraph 2 may be enforced provisionally. The reasons for the decision are as follows. Unless there are exceptional circumstances when a patentee, etc., has transferred a patented product to third party, the patentee's patent right in the product shall be exhausted as having achieved its purpose. However, if the patented product has been processed or modified to the extent that the identity of the original product is lost, it can be evaluated that the patentee's patent right shall be considered infringed. Here, it shall be decided whether a patented product has been processed or modified to the extent that the identity of the original product is lost, and therefore the act of producing has been taken place based on a comprehensive assessment of the description of the patented invention, the objective nature of the product, the use form, and the legislative purpose of the Patent Act, and so on. First, the description of the patented invention wallpaper is as follows. The patented wallpaper is exclusively used for article packaging devices. It concludes magnets on the core tube, and the magnets are arranged to measure locations by the rotation angle sensor in the article packaging device. This enables the rotation angle of the wallpaper itself to be precisely measured and the braking force to be properly adjusted according to the external diameter of the wallpaper. Second, the objective nature of the plaintiff patented product is as follows. The plaintiff manufactured and sold the wallpaper on the premise that the core tube of the wallpaper would be used one time. When the core tube is reused after one-time use of the plaintiff patented product, it is difficult for ordinary user to remove the core tube. In addition, securing the quality of the core tube of the plaintiff wallpaper is difficult. It is reasonable to conclude that the plaintiff patented product has lost its utility after one-time use. Finally, the use form of the product is as follows. The plaintiff patented product is exclusively used in the plaintiff packaging device, and the packaging sheet part makes up a distinctive portion of the composition of the plaintiff wallpaper. In addition, as examined above, the plaintiff patented product loses its utility after it is used up. Therefore, it is reasonable to conclude that replacing the packaging sheet to the plaintiff core tube cannot be regarded as replacing a consumable component under normal use, and rather as replacing the component that constitutes an essential portion of the invention. Therefore, the Defendant's Act infringes the plaintiff patent rights, and the plaintiff argument is well-grounded. For this reason, the lower court decision rendered shall be revoked. Thank you very much.
以上で大韓民国チームによる模擬裁判を終了いたします。ご登壇の皆様、ありがとうございました。